ओके सो इस वीडियो में हम बात करने वाले हैं लॉ के कंपनीज एक्ट के सेक्शन नंबर 5 यानी कि आर्टिकल्स ऑफ एसोसिएशन के क्वेश्चन आंसर्स के बारे में। मेरे पास ये इंद्रेश्वर की क्वेश्चन बैंक है। अगर आपके पास कोई भी क्वेश्चन बैंक हो आप लेके बैठ सकते हैं। कुछ क्वेश्चंस सब में तो होते ही है, उसमें से वैसे ही क्वेश्चंस हैं, ठीक है। सो लेट्स स्टार्ट ओके। Section number 5 Articles of Association. The question is role of doctrine of indoor management is opposed to that of the role of constructive notice. Comment on this statement with reference to the Companies Act 2013. Doctrine of indoor management. According to this doctrine, person dealing with the company cannot be assumed to have knowledge of internal problems of the company. They can simply assume that all the required things were done properly in the company. Stakeholders need not to inquire whether the necessary meeting was convened and held properly or whether the necessary resolution was passed properly. They are entitled to take it for granted that company had gone through all these proceedings in a regular manner. The doctrine helps protect external members from the company and states that people are entitled to presume that internal proceedings are as per the documents submitted with the registrar of the companies. The doctrine of indoor management was evolved around 150 years ago. ये सभी लिखने की काय को जरूरत है? The role of doctrine of indoor management is opposed to the role of doctrine of constructive notice. Whereas the doctrine of constructive notice protects a company against outsiders, the doctrine of the indoor management protects outsiders against the actions of the company. This doctrine also is a possible safeguard against the possibility of abusing the doctrine of constructing notice. Basis of doctrine of indoor management नहीं, हाँ, एक्सेप्शन टू डॉक्ट्रिन ऑफ इंडोर मैनेजमेंट। एक्सेप्शन ऑफ डॉक्ट्रिन ऑफ इंडोर मैनेजमेंट जो है वही क्या है? एप्लीकेबिलिटी ऑफ डॉक्ट्रिन ऑफ कंस्ट्रक्टिव नोटिस. First point is knowledge of irregularity. In case outsider has actual knowledge of irregularity within the company, the benefit under the rule of indoor management would not would no will would no longer be available. In fact, he or she may well be considered part of irregularity. Negligence if with a minimum effort the regularity within the company could be discovered, the benefit of the rule of indoor management would not apply. The protection of the rule is also not available in the circumstances where company does not make proper inquiry. Forgery. The rule does not apply where a person relies upon the document that turns out to be forged, since nothing can validate forgery. A company can never be held bound to the forgeries committed by its officers. The above doctrine have been well considered while framing the provisions of various acts pertaining to the companies worldwide. The Companies Act 2013 and earlier acts relevant for the companies in India are no exception to the same. ये लास्ट पैराग्राफ में लिखने की कोई ज़रूरत नहीं है. फिर नेक्स्ट क्वेश्चन, द आर्टिकल्स ऑफ एसोसिएशन ऑफ अ कंपनी में कंटेन प्रोविजंस फॉर एंट्रेंचमेंट. एंट्रेंचमेंट हमेशा ज़्यादा जरूरी बन जाता है, फाउंडेशन में तो और भी ज़्यादा होता है, लेकिन यहाँ पे इतना ज़्यादा नहीं, लेकिन हाँ इस चैप्टर में इंपॉर्टेंट तो है बाकी के सेक्शन से कंपेयर में. Provisions for entrenchment under Section 5 of the Companies Act 2013. What is meant by the entrenchment provisions in this context? Also state relevant provisions of the said act dealing with the entrenchment provision. Entrenchment usually an article of association may be altered by passing resolution, but by passing special resolution, but entrenchment make it more difficult to change it. So entrenchment means making something more protective. Section 5 of the Companies Act 2013 describe the provisions relating to entrenchment. Articles may contain provisions for entrenchment. The articles may contain provisions for entrenchment to the effect that specified provisions for the articles may altered only if conditions or procedures as that are more restrictive than those applicable in case of special resolution are met or complied with. Manner of inclusion of entrenchment. The provisions for entrenchment shall only be made either on the formation or by amendment to the articles agreed by all the members in case of private company and by passing special resolution in case of public company. Notice to the registrar for the entrenchment provision where the articles contain provisions for entrenchment, whether made on formation or by amendment, the company shall give notice to the registrar of such provisions in such form and manner as may be prescribed. Next question is, the person not being member dealing with the company are always protected by the doctrine of indoor management. Explain. Doctrine of indoor management. According to this doctrine, persons dealing with the company need not to inquire whether the internal proceedings relating to company were followed correctly. Once they are satisfied that the transaction is in accordance with the memorandum and articles of association, stakeholders need not to inquire whether the necessary meeting was convened and held properly or whether the necessary resolution was passed properly. They are entitled to take it for granted that the company had gone through all the proceedings in a regular manner. The doctrine helped to protect external members from the company and said the people are entitled to presume that internal proceedings are as per documents submitted with the registrar of companies. The doctrine of indoor management is opposite. The doctrine of indoor management is opposite of the doctrine of constructive notice, whereas the doctrine of constructive notice protects a company against outsiders. The doctrine of indoor management protects outsiders against the actions of the company. This doctrine also is a safeguard against the possibility of abusing the doctrine of constructive notice. Next question is, Articles of Association of XYZ Limited provides the board of directors authority to issue bonds provided such issue is authorized by the shareholders by necessary resolution in the general meeting of the company. The company was dire need in funds and therefore it issued the bond to Mr. X without passing any such resolution in general meeting. Can Mr. X recover the money from the company? Decide referring to the relevant provisions of the Companies Act 2013. अकॉर्डिंग टू द इंडोर मैनेजमेंट, डॉक्ट्रिन ऑफ इंडोर मैनेजमेंट वाला ही है यहाँ पे, कंपनी इज बाउंड टू मिस्टर एक्स सिंस द लेंडर मिस्टर एक्स हैड lent the money to the company assuming that the company was authorized to borrow money after obtaining authorization from the members in the general meeting. Since on the same facts the court held, केस लॉ का रेफरेंस देना यहाँ पे रॉयल ब्रिटिश बैंक वर्सेस टर्केंड, यहाँ पे इसको टर्केंड्स रूल भी कहते हैं ना, हाँ टर्केंड, रॉयल ब्रिटिश बैंक वर्सेस टर्केंड, that the outsiders dealing with the company were not required to inquire into the internal management of the company, and outsiders were entitled to assume that as far as internal proceedings of the company were concerned, everything had been done regularly. So the conclusion is, in the present case, XYZ Limited will be bound to return the money to Mr. X. Next question is, the director of Smart Computers Limited borrowed the sum of money from Mr. Tridev. Same लग रहा है मेरे को. Company's articles provided the directors may borrow on bonds such sum may from time to time be authorized by the resolution passed at the general meeting. The shareholders claim that there had been no such resolution authorizing the loan and therefore it was taken without the authority of the company, and the company is not bound to repay loan to Tridev. In light of the contention of the shareholders, decide whether the company is bound to pay a loan. Same to same copy paste, self conclusion पढ़ रहा हूँ मैं यहाँ पे भी. In the given case, Mr. Tridev being a person external to the company need not to inquire whether the necessary meeting was convened and held properly and whether necessary resolution was passed properly. Even if shareholders claim that no resolution authorizing the loan was passed, the company is bound to pay the loan to Mr. Tridev. Next question. The person not being the members dealing with the company are always protected by the doctrine of indoor management. કેટલું છે યાર. explain the doctrine of constructive notice. देखो यार, ये फिर से ना दो ही क्वेश्चन आ रहे हैं बार बार, मतलब एक क्वेश्चन शायद दूसरा आया, वो था एंट्रेंचमेंट वाला, बाकी सिर्फ दो ही क्वेश्चन मैंने अभी तक देखे. कौन कौन से? डॉक्ट्रिन ऑफ इंडोर मैनेजमेंट, डॉक्ट्रिन ऑफ कंस्ट्रक्टिव नोटिस. या तो डायरेक्ट क्वेश्चन या तो केस लो घुमा घुमा के, बस ये दो ही पूछ रहा है सिर्फ। नेक्स्ट क्वेश्चन पढ़ते हैं, ये अब नहीं पढ़ने वाला मैं अभी। Yadav Dairy Products Private Limited has registered its articles along with the memorandum at the time of registration of the company in December 2014. Now, directors of the company are of the view that the provision of articles regarding forfeiture of shares should not be changed except the resolution of 90% majority entrenchment वाला आ जाएगा अभी। While as per the section 14 of the Companies Act 2013, articles may be changed by passing special resolution only. Hence, one of the directors is of the view that they cannot make provision against the Companies Act 2013. You are required to advise the company on this matter. भाई काय को अपन अगेंस्ट थोड़ी जाएंगे, अपन बीच का रास्ता निकालेंगे, उसको नाम क्या देंगे, एंट्रेंचमेंट। As per Section 5 of the Companies Act 2013, the articles may contain provisions for entrenchment to the effect that specified provisions of the articles may be altered only if more restrictive conditions than special resolution are met. The provisions of the entrenchment shall only be made either in the formation of the company or by the amendment in the articles agreed by all the members in the private company or by passing special resolution in the public company. Whether the articles contain provisions of the entrenchment, where the articles provision for the entrenchment, whether made on the formation or by amendment, the company shall give the notice to the registrar of such provisions in prescribed form and manner to the registrar. Conclusion: in the present case, Yadav Dairy Products Private Limited is private company and wants to protect the provision of articles regarding the forfeiture of shares. It means it want to make entrenchment of articles which is allowed, but the company will have to pass a resolution taking permission of all the members क्योंकि private limited है, and it should also give notice to the registrar of the companies regarding entrenchment of articles. Next question. Mr. Shyamlal is a B.Tech in computer science. Is a B nahi, is a B.Tech in computer science. He has promoted an IT startup and got into registered as private limited company. Initially, only he and his family members are, इसमें भी सेम होगा, पहले खुद के फैमिली मेम्बर्स है, वाइल आर्टिकल्स ऑफ ड्राइविंग कोई भी ना, मतलब श्यामलाल ने ऐसा प्रोविजन डाल दिया कि भाई वो ही आर्टिकल रहे, मतलब वो ही डायरेक्टर बनेगा। फिर उसके एक क्लोज मित्र मिस्टर मेहरा ने बताया कि श्यामलाल जैसे ही, अभी भले तेरे फैमिली है लेकिन 75% पास करके वो तो निकल लेंगे, मतलब तेरे को निकाल भी सकते हैं। तो अभी वो तुम्हारे पास आया रोते रोते कि साहब मेरे को रास्ता बताओ साहब, अपन क्या बोलेंगे, एंडेंसमेंट लगा ले, ठीक है। ऑल द मेंबर्स प्राइवेट कंपनी, कुछ भी नया पॉइंट नहीं है, हाँ, लेकिन कंक्लूजन पढ़ लेते अभी, ठीक है। एंट्रेंचमेंट वाला सेक्शन 5 का रेफरेंस देना है, बोलना है कि भाई एंट्रेंचमेंट ना या तो अपन कंपनी चालू हो तब रख सकते हैं या ऑन द फॉर्मेशन और बाय अमेंडमेंट। फिर ऐसा लिखना है कि अगर प्राइवेट कंपनी है तो अप्रूवल बाय ऑल द मेंबर्स, पब्लिक कंपनी है तो बाय पासिंग स्पेशल रिजोल्यूशन, और जैसे ही अगर आर्टिकल्स में जैसे ही तुम्हारा एंट्रेंचमेंट का प्रोविजन डालो ऑन फॉर्मेशन और बाय अमेंडमेंट, it should be registered with the registrar of the company within prescribed limit in prescribed form and manner. उसके बाद बस यही सब लिखना है। उसके बाद क्या, कंक्लूजन, उसके बाद तो कंक्लूजन अपन भी पढ़ लेते हैं। इन द सेड सिचुएशन द IT startup company is a private company, therefore Mr. Shyamlal can get articles altered which is agreed to by all the members, whereby the amendment articles will say that he can be removed from the post of directors only if say 95% vote are cast in favor of the resolution and give notice of the same to the registrar। मतलब यहाँ पे यहाँ पे क्वेश्चन में कोई परसेंटेज नहीं दिया था, लेकिन अपना मन गढ़त बना दिया कि भाई 95% का वोट लगेगा मेरे को निकालने के लिए, ठीक है, ऐसा श्यामलाल ने कर दिया। यहाँ तक सारे क्वेश्चंस हो गए हैं सेक्शन नंबर 5 के। क्या क्वेश्चंस आए आर्टिकल्स ऑफ एसोसिएशन में? पहले तो सेक्शन नंबर 5 आर्टिकल्स ऑफ एसोसिएशन, ज़्यादा से ज़्यादा क्वेश्चंस आए डॉक्ट्रिन ऑफ इंडोर मैनेजमेंट, डॉक्ट्रिन ऑफ कंस्ट्रक्टिव नोटिस एंड एंट्रेंचमेंट, ये 3 ही चीज़ आई है, बाकी कुछ आया ही नहीं है इससे, तो ठीक है, ख़त्म, बाय बाय।